Welcome to the University of Tokyo International Law Hub and Human Rights Watch seminar on Magnitsky Law, that is on human rights sanctions. This is number 2. My name is Ai Kihara-Hunt. I'm Associate Professor at the University of Tokyo, and I also direct the International Law Hub. Now, if I can invite Satoko Haru from the International Law Hub to give a very brief summary of where this seminar comes from and with the admin note. Haru-san, please.
Yes, well, good evening, everyone, and thank you all for participating in this seminar titled Magnitsky Law Comparative Analysis. This event is a joint seminar by the University of Tokyo Law Training and Research Hub and Human Rights Watch, and is co-organized by the Graduate School of Human Security, the Research Center for Sustainable Peace, and the Global Studies Initiative. And it follows the symposium held back in March this year that introduced the origin of the Magnitsky sanctions framework and how Magnitsky sanctions have been implemented in the US, Canada, and the UK. The symposium, was recorded and available through the link sent in the chat box. I will send it in a bit. The first Magnitsky Act was the Global Magnitsky Act in the US, initiated by Mr. Bill Browder, co-founder and CEO of Hermitage Capital Management, who, after the torture and subsequent death of his legal staff, Sergei Magnitsky, tried strengthening accountability for human rights violations. The legislation allows the US to put economic and social sanctions against human rights violators and those who practice corruption through travel bans and or asset freezing. Following the US practice, currently there are over 30 countries that have similar Magnitsky frameworks. The Magnitsky framework is important because human rights defenders are often targeted by groups or governments, sometimes with fatal consequences. The Magnitsky law sanctions individuals rather than states. There are still a lot of space for improvement, including a more effective inclusion of the civil society in the identification process. And Magnitsky frameworks differ from country to country, so sharing knowledge and experience among us and building an international network is very important. In this seminar, we will discuss the situation in the EU, Australia, and Japan. Please note that all questions for the Q&A will be taken through the chat functions. Just very quickly in Japanese, 本日は同時通訳機能も使用できます。右下のボタンを、Interpretation って書いてあるボタンをクリックしていただきますと、通訳の言語を選択することができます。Thank you.
Okay, thank you very much, Satoko-san. Now I'd like to ask Paul Namkoong of the International Law Hub to highlight some points of comparison of various Magnitsky framework. So, Paul?
Hello, everyone. My name is Paul Namkoong. I'm a student at the University of Tokyo. I'm an editor for the Tokyo International Law Hub. I spent a number of months working and researching for a previous symposium in collaboration with Human Rights Watch about increasing awareness of the Magnitsky Act around the world, but also specifically for a Japanese implementation of it. And today I'd like to introduce to people who aren't as familiar with this approach or with this movement, what Magnitsky Acts are, firstly, why they're so valuable in the landscape of human rights today, and 3 areas of convergence and divergence that I've noticed in my research between each law. So firstly, just to explain this, I made a diagram previously just simply explaining what Magnitsky Acts do and kind of just visually representing them. So essentially, they just create tangible consequences for human rights abusers. And it's something that even a student like me can understand. It's just, it features an asset freeze. So any sort of property or financial assets in the state that implements the Magnitsky Act will be frozen and unavailable to the perpetrator or the target of sanctions. It's a travel ban, so they won't be able to arrive or go to that country or state. And then there's also inclusion on public lists, which is a very underrated aspect of Magnitsky sanctions, I'd say, because they put you on a list and your name is kind of just proliferated to media or to other states so that they can coordinate in their sanctions. So again, what's important here is that Magnitsky sanctions, they allow for not criminal procedures because it isn't a criminal procedure, but they are economic sanctions. So again, they can somewhat bypass issues like jurisdiction and kind of evidentiary standards that prevent other human rights procedures from really punishing the worst perpetrators of abuses. So again, I'd like to refer you to this quote from Jeffrey Robertson, who is a renowned barrister and also wrote a book recently just talking about how Magnitsky sanctions or just alternative, essentially like economic and criminal procedures can help protect human rights around the world. So he said, at a time when international criminal law is faltering, the global justice movement should look to Magnitsky laws as a means of naming, blaming, and shaming human rights violators. And again, it's somewhat of a plan B that might actually end up being more effective in this current environment. So as I said before, I spent months researching the differences, kind of compartmentalizing each country's Magnitsky law or their proposals of it. And I came up with kind of 3 variables where either states are converging towards it recently with innovations, or like in the last month or so even, and kind of 3 areas where they also diverge and are important to their effectiveness, in fact. So the first one is procedural fairness. So it's the right of reply. You want your legislation that deters and punishes human rights abuses to itself be respectful of human rights. So the best feature to ensure that a country's Magnitsky Act complies with fundamental human rights is to implement some sort of due process for targets. And that's something that wasn't necessarily implemented in the beginning or the inception of the Magnitsky Act, but something that's kind of evolved to become essential, an essential part of it. So you want the targets themselves to be able to challenge and also have their sanction reviewed by a party, preferably a requirement to do so. An example here that I'd like to provide is Youssef Nada, who is actually not a target of Magnitsky sanctions, but previous individual terrorism sanctions. And the problem there was that he had no right of reply or no party to really listen to his requests. So he was kind of in this gray zone for a few years and unable to fly to get medical treatment and kind of the proper care that he needed because of these sanctions. And that's where the respecting the human rights of alleged targets is important. So if we look at which countries kind of have these provisions, only the US originally did not allow or have a function for alleged perpetrators to seek judicial review, but the state has introduced general mechanisms to request review for just individual sanctions as a whole. So that includes Magnitsky sanctions. And the rest seem to think that it is like a fundamentally important requirement to protect the human rights of the targets, as I said before, even if these challenges may not lead to anything. And moving on. So as you can see in the provisions for the EU Global Human Rights Sanction Regime, which is their version of the Magnitsky Act, they have provisions for hearing a target response and a requirement that the kind of deciding body needs to review these challenges. And not only do these laws have requirements for the response, but they also have a lot of other humanitarian exemptions for asset freezing. So they'll provide money for satisfying their basic needs, quote unquote, and the needs of quote, dependent family members or food or even mortgage to pay legal fees. And moving on, the second category I'd like to discuss is the inclusion of corruption as a sanctionable offense. And this has kind of changed in one state that I'll mention soon. So there are intrinsic connections between the prevalence of corruption and the incidence of human rights violations in any given state, right? And that's why it's included in the Magnitsky Act. Again, Sergei Magnitsky, the person kind of the act was named after, uncovered a huge corruption scandal in Russia, and his ill treatment was motivated by the perpetrator's desire to keep that corruption hidden and ongoing. So case in point, the UK sanctioned just a few weeks ago 2 Indian businessmen operating in South Africa who were engaged in corruption to kind of obtain government contracts in that country. So it's not just, again, I'd like to emphasize, it's not just state officials who can be sanctioned by the Magnitsky Act, but it can be private businessmen. And there's a lot of examples to support that. And not just businessmen also. But just when we're comparing across states again, you can see that the UK used to not have it as a kind of sanctionable offense, and I'll go into that a little further. But the UK and especially the EU does not include corruption within their sanctionable offenses. But until a few weeks ago, So when the UK updated its anti-corruption tool and sanctioned 14 Russian officials retrospectively involved in the kind of human rights abuses of Sergei Magnitsky, again, they're trying to update and kind of converge with the rest of the Magnitsky movement, as I argued. Okay, and the third category and the final category I'd like to talk about today is productivity. So as I wrote there, how active is the state in sanctioning perpetrators? So how often do they update their sanctions, and which groups do they accept recommendations from? Is it just from within their government? As we'll see in some countries where that's really limited the productivity of the Magnitsky Act, or do they accept from a wide range of third parties? Do they have a lot of processes to guarantee that they're being listened to? And I think this actually might be the biggest difference between countries' Magnitsky Acts and in kind of determining their effectiveness, or at least how frequently they're updated. And alongside having a solid framework for sanctioning people fairly and effectively, you really would like the state to be productive in applying them. And the government itself is not going to be able to invest the resources and time required to collect evidence on all these human rights abusers or violators. And that's where collaboration with NGOs has been key for states who encourage that kind of interaction with their deciding committee. And on the point of productivity, again, I'd like to point to two examples from the US, where the US acted very quickly in sanctioning China compared to other countries, or like Chinese state officials, concerning the actions with the Uyghur minority. And in my opinion, there is a correlation between the productivity of a state's Magnitsky Act and the openness of submissions, or how accepting each state is of third-party recommendations. So case in point, I'd like to refer you to this table that I kind of collated. So I tried to see the sanctions list and see how they differed. And there's a clear difference here. So the US, although it kind of has a head start in when their Magnitsky Act was implemented, they have over 300 entities and individuals sanctioned, and is constantly updating its sanctions regime, and with a lot of reports submitted from NGOs, as I'll explain right now. So Global Witness, for example, and a lot of other NGOs, even Human Rights Watch, identifies high-powered officials and political elites engaging in these violations, and they directly publish reports, and that gets sent to the US kind of deciding body. Is case in point, some Cambodian military officials that get on to the Magnitsky list. And beyond working with other governments, I think NGOs provide two important returns. They raise awareness of the law, and they're very important in identifying these violators. So in conclusion, again, I'd just like to cover what's next for the Magnitsky movement. So it was passed in 2016 at first, and then upgraded in the US, and now it's being proposed in a lot more countries, including Japan, including Taiwan, including Australia. And I believe that with more and more countries adopting these Magnitsky Acts, human rights violators will find it extremely difficult to kind of store money obtained from corruption abroad, and it can be a very solid deterrent and a viable plan B, as Jeffrey Robertson stated. Thank you.
Thank you very much, Paul. Time to the dot. Now let me go on to our keynote speakers. We have 3 keynote speakers to provide perspectives from the EU, Australia, and Japan. And we also have a special guest who was not on the program. So first, may I invite Professor Clara Portela, professor at the University of Valencia, and her research focuses on arms control, non-proliferation, and disarmament, but most importantly, also on multilateral sanctions policies. So please, Professor Portela, you have the floor.
Thank you very much, and I take the opportunity to thank you for inviting me to this discussion. So I have been I'm hoping that everybody can hear me. Okay, so basically what I'm going to do is I'm going to give a brief introduction to the Magnitsky law that has been approved in the European Union. Now, first of all, even though this Magnitsky law is very clearly linked to the US version and also the Canadian version, there was a lot of resistance on the side of the EU to call this Magnitsky. So its official title is the EU Human Rights Sanctions Regime. So the idea was to obviate the name of Magnitsky in order to dispel any idea that the sanctions regime was specifically targeted at Russia. So the idea was really to make it sound really global in scope. Now, in the few minutes that I'm going to speak, what I'm going to be focusing on is the factors in this EU sanctions regime that facilitate convergence with the listings that will be approved or that have already been approved in similar legislation elsewhere. So I'm hoping that this can be useful for the reflection as to what should be the ideal shape of the Magnitsky law equivalent in the Japanese context. So basically what I'm going to focus on is, first of all, the fact that this is, I would like to position myself. It is innovative and it is a good idea, but at the same time, it is full of risks and one has to be careful with how this type of legislative framework is employed in practice. So how the key question is who and who will be designated and in which quantity will these designations take place. Now let me explain myself. First of all, the type of a sanctions mechanism that is embedded in the Magnitsky law, in the EU Magnitsky law, is rather novel in the European context, because the EU has a long-standing practice of imposing sanctions, in most cases, in order to address situations of human rights violations, mostly connected to democratic backsliding. So this is absolutely no novelty in the EU sanctions context. However, the designation logic that follows a thematic rather than a geographical focus is new in the European context. So we have, in other words, we have a long practice of the European Union imposing sanctions for human rights violations, but these sanctions are always linked to a crisis in a specific country. Now, this horizontal logic that has been adopted from the US practice only exists in the EU, only existed in the EU up until 2018 in the form of the anti-terrorism list, which is actually a UN promoted idea. So for a very long time, we only had a horizontal list, which is the anti-terrorism list. And starting in 2018, some horizontal listings started to emerge. One of them counters the employment of chemical weapons, and another one is meant to react against cyber attacks. So the human rights sanctions regime in the EU has been the very first tool employed by the EU to address human rights violations outside a geographical or country crisis. And secondly, it is the fourth horizontal sanctions regime that the EU has put in place. So let's say that the EU is still adjusting to this new logic for the imposition of sanctions. Now, the key point here is what sort of difficulties is the EU likely to encounter when it comes to adopting listings that are similar to the listings adopted by like-minded partners, meaning other countries that have already adopted or that are likely to adopt soon a similar framework for listings. And I mean, we are talking, as already mentioned by the previous presenter, obviously by the US, who has been the main promoter, Canada, the UK, which adopted the sanctions regimes before the EU adopted its legislation in December 2020, And I mean, we are now waiting for Australia and Japan to adopt similar legislation. Now, the efficacy of these measures is going to be magnified by the fact that all of these like-minded partners adopt the same designations or similar designations. If every sanctions issuing country opts for different designations, then the global effect of the sanctions will be very much diminished. So in other words, the whole point of having a number of like-minded countries adopting this legislation is precisely in order to achieve a maximum number of overlapping designations, so that the same individual or the same entities face difficulties in operating in the maximum number of countries. Now, let me now highlight what these challenges are in the European case that might affect the ability of the EU to adopt sanctions together with the other like-minded partners. Now, one of them has to do, obviously, with the problem of judicial review that the previous speaker has already alluded to. The EU has a very stringent due process system. It is actually much more stringent than the one that we have in the US, so that the ability of the EU to designate individuals is always linked to the existence of sufficient documentation that the EU could put on the table in cases in which the blacklisted individual files a case with the European Court of Justice. Now, the Court of Justice of the European Union has a tradition of ruling often in favor of the claimants. So, for a number of years, actually, most claimants got a positive ruling from the Court of Justice of the European Union. The situation now looks a bit more favorable to the Council, but this is to say that this has created a very serious challenge for the EU, and it has, the Council has been able to mitigate it, but it's still, it is still very much constrained in the number the number of people and the nature of reasons that it can for which these individuals have to be or can be listed. The second challenge is that the EU did not include corruption, as already mentioned by the previous speaker. Now, just yesterday, the European Parliament passed a resolution calling for the inclusion of corruption into the already existing human rights sanctions regime. So, we have civil society activism, and we definitely have a European Parliament that is very favorable to this idea. But the Council is not obliged to follow the recommendation of the European Parliament. So we still don't know whether this is going to lead to a situation in which the Council agrees to expand the scope of the sanctions regime to corruption cases. And actually, this would be quite a novelty in the context of European Union sanctions practice, because it has a very, very limited practice of imposing sanctions to address situations of corruption. So this would actually be quite a breakthrough in case that this happens. But of course, for as long as we have no provisions on corruption in the sanctions regime, there are a number of targets that simply cannot be included, and this will favor a discrepancy between the listings in other like-minded partners and the listings in the EU. Now, the third point that I would like to highlight is the fact that the EU has it has no provisions on delisting in the sanctions legislation, in contrast to what happens with the original U.S. Global Magnitsky Act. So the U.S. Global Magnitsky Act contemplates a number of cases in which the individual might be delisted. And one of them has to do with the existence of foreign policy interest of the United States. So if they are affected, then there might be, the president would be authorized to delist these specific designations. There is also a possibility for seeing that if there is, if the target shows repentment and makes a commitment not to commit similar actions in the future. This might also lead to delisting, but most importantly, in cases of appropriate prosecution, there is the possibility of delisting is also open. So if the individual is being prosecuted elsewhere, the listing loses its relevance. It becomes obsolete. So this actually highlights how the listing under the Global Magnitsky Act is closely linked to criminal law or even to international criminal law. In the EU, we have no provisions specifying when an individual might be delisted. So this actually leaves the designees with the only option of challenging their designation in front of the Court of Justice, which again feeds into this due process issue that I have already alluded to. And finally, another challenge that is specific to the case of the EU has to do with implementation and enforcement. Now, the inclusion in the human rights sanctions regime by the EU has two main consequences. One of them is that you are not allowed to travel into European territory. And secondly, designees are also prohibited from receiving any transactions coming from the EU or any company in any company or person in the EU. And any assets that they might have in Europe, including bank accounts or any other assets, they would be frozen. Now, as far as the transaction and freezing of assets aspect is concerned, implementation is in the hands of the community institutions. So this is something that has to be, is fully enforceable. So member states who, if any member state fails to abide by these prohibitions, then there is a possibility of bringing this member state to court because of lack of compliance with European law. However, with visa bans, with the prohibition to travel to the EU, no similar provisions exist. So implementation is in the hands of the member states, and there is nobody. There are no powers that allow the institutions to enforce such a visa ban. So in case that any member state fails to comply and actually allows the entry or even invites any of the blacklisted individuals to the country, there is no possibility of enforcement on the side of the EU. Now, this is very specific to the multi-level governance and to the legal order of the EU, but this obviously also has the consequence of potentially weakening the force of the validity of the effectiveness of the EU human rights sanctions regime, because basically both designees and member states are aware that a lack of compliance would have no consequences for them. Okay, so I think that I have already highlighted the main aspects that set the EU sanctions regime apart from the sanctions regimes of other like-minded partners, particularly in comparison to the US Global Magnitsky Act. So I look forward to your comments and to the discussion. Thank you very much.
Thank you very much, Professor Portela. That gives us a lot to discuss. Now, maybe if I can invite Mr. Simon Henderson, Chief of Policy at Save the Children in Australia, and he's been involved in the parliamentary inquiry process in relation to Magnitsky framework. So without further ado, please, Mr. Simon Henderson.
Thank you very much. Thank you to Human Rights Watch and the University of Tokyo, International Law Training and Research Hub for organising this seminar today. I'd like to begin by acknowledging the traditional custodians of the land upon which I'm speaking, the Gadigal people of the Eora Nation, and pay my respects to their elders past and present, and I extend that to any Indigenous peoples who are on the call today. My presentation will cover three different issues. Firstly, I'll talk about Australia's existing sanctions structure and how it's applied, including its deficiencies. Secondly, I'll provide updates on the push for Magnitsky laws in Australia, and I'll cover the parliamentary inquiry. And thirdly, I'll talk about the next steps surrounding advocacy for Magnitsky laws in Australia. So, how are Australia's sanctions laws currently framed? Well, Australia has two primary sanctions mechanisms. Firstly, Australia implements UN Security Council sanctions under the Charter of the United Nations Act 1945 and its associated regulations. And secondly, under the Australian Autonomous Sanctions Regime, that's under the Autonomous Sanctions Act 2011 and the Autonomous Sanctions Regulations 2011. The Charter of the United Nations Act enables a listing of certain countries, individuals or entities, and that refers to definitions of sanctions that UN sanction enforcement law applies. And so that can be quite broad. For example, that might apply to a particular individual who's accused of terrorism activities. Secondly, the Autonomous Sanctions Act itself defines autonomous sanctions as a tool to influence a foreign government's policy, a member of a foreign entity, or another person or entity outside of Australia, or prohibit the conduct of engagement of that person. For example, a case where that's been used in March 2019, the foreign minister imposed financial sanctions on travel bans on 7 Russian individuals for their role in the interception and seizure of Ukrainian naval vessels. So what are the actions that trigger sanctions in Australia? The Autonomous Sanctions Act itself doesn't include sanctions on any persons or entities. That's performed by the regulations. Subsection 10(1) of the regulations gives the Governor-General the authority to make regulations in a very broad sense. So that can include the prescriptions of persons or entities, restrictions on the prevention, use, dealings and availability of assets, restrictions or prevention on the supply, sale or transfer of goods and services and more. Before the Governor-General makes these regulations, the minister responsible has to ensure that the particular actions will won't facilitate the conduct of Australia's relations with outside countries or entities, or otherwise deal with things or relationships outside of Australia. So how are the autonomous sanctions applied in practice? So it's a two-step process. So the minister themselves has to advise the Governor-General to amend the regulations and then identify the target country and the activities for which a person or entity must be designated. Then the minister must make a second instrument to designate that specific person or entity, and they must be satisfied that they meet the sufficient criteria, which again is framed very broadly. For example, one of the regulations allows for the listing of a person or entity if they're contributing to the proliferation of weapons of mass destruction, but doesn't really contain details on whether the conduct itself is related to that particular action. So where does Australia currently impose sanctions under this autonomous sanctions regime? Well, they're very broad at present, and some sanctions are applied under the autonomous sanctions regime and the UN Security Council sanctions regime, and they do overlap. So in cases such as North Korea, Iran and Libya, there's an overlapping. Autonomous sanctions are applied in some cases to countries such as Myanmar, Russia, or Ukraine, but then are not separately applied under the UN Security Council, and that is for reasons that many of the presenters have talked about before. So what are the penalties involved if somebody breaches sanctions laws? Well, they can be quite substantial. The Autonomous Sanctions Act imposes criminal offences for contravening a sanctions measure unless you have a sanctions permit. So an offence can be punishable by imprisonment for not more than 10 years, or a fine as well, as substantial fine, and a body corporate can also be charged with a fine as well. But there are real substantial deficiencies in Australia's autonomous sanctions regime, which has led to this momentum about Magnitsky sanctions law reform in Australia. It's currently not fit for purpose and lacks a degree of flexibility and precision. Firstly, the current sanctions regime fails to target human rights abuses, violations of international humanitarian law, or acts of corruption. There are no references in the Act or the regulations to these particular measures. So while in the regulations itself, specific countries may have reference to human rights abuses, there's no requirement for that sanction to be linked to the human rights abuse. And even if they do refer to human rights, a good case is Zimbabwe, the sanctioned activity doesn't contain information on what human rights abuses are actually being targeted. Secondly, there's a lack of information about criteria or evidence used to make sanctions. So the acts and regulations don't provide enough guidance for policy makers, and there would be policy decision makers that sit within the Department of Foreign Affairs and Trade or the Ministry of Foreign Affairs equivalent to take an initial assessment of what criteria they need to be following. There's no explanation beyond a few sentences around the assessment process. Additionally, there's a lack of civil society engagement. There is no requirement for civil society to be involved in the process, nothing in the Act or regulations to reference that need to consult, which contrasts with the US Global Magnitsky Act. Then additionally, there's no parliamentary oversight. So the Autonomous Sanction Act lacks mechanism for parliamentary oversight. There's no reporting, there's no review process, which is in stark contrast to Magnitsky legislation in other countries. So then what is the current status around Magnitsky laws in Australia? And as I was mentioning, there's been quite a few discussions in Australia about the development of a Magnitsky law, citing the deficiencies within the Autonomous Sanctions Act. In 2018, there was a private members bill that was introduced by an MP, Michael Bamby, through a bill that was called International Human Rights and Corruption Magnitsky Sanctions. It failed to progress beyond its introduction and lapsed prior to an election. But despite the best intentions, it had significant gaps and didn't have bipartisan support. There is a recognition that existing sanctions regime are difficult to give effect to, and that combined with international developments elsewhere has led to bipartisan support for a Magnitsky Act. In December 2019, the Minister for Foreign Affairs asked the Joint Standing Committee on Foreign Affairs and Defence and Trade to inquire into the development of the Magnitsky Act. They called for submissions. Submissions were sought by 30th of April 2020. 162 organisations made submissions, Uyghurs, Tibetans, Cambodians, Hong Kongers, a very wide mix of organisations, including Save the Children. I made multiple submissions. There were 8 public hearings, and I also appeared in one of those public hearings. Some of the key themes that came out through the submissions and public hearings was this need for a broad phrasing around what would encompass a sanctionable activity. So looking at whether or not there would be qualifications for that sanctionable activity. Would it be gross? Would it be serious? Would it have any other qualifier? the need for specific provision in legislation on the role of civil society. So really important to see how there are gaps in diplomatic frameworks or that civil society can fulfill. Often they have a better footprint on the ground in countries than the Australian government might have. The need for an independent assessment process. So there was support for an independent advisory body to be created to receive nominations, consider them and make recommendations for a decision, giving more public confidence in the process of the nomination. There was also strong support for the need for a process of judicial review and due process. So ensuring that individuals have the opportunity to challenge designations and show that humanitarian exemptions, which is very important for international NGOs in particular, would be applicable. Finally, that there was a strong attention on the need for annual reporting. So there was support for a comprehensive reporting process more akin to the US model, requiring an annual report that prescribes a format and an outline for dates for submissions that have been granted. So how did what was the view of the government and government departments through the inquiry process and what's happening now? Well, despite the support from senior parliamentarians on both sides, the view from the Department of Foreign Affairs and Trade was not supportive. They opposed the development of the Magnitsky Sanctions Act on the following grounds. They viewed that there should be an amendment of the existing autonomous sanctions regulations to introduce, if there was to be Magnitsky-style measures. They opposed a requirement in legislation for civil society to be consulted. Thirdly, they believed that sanctions applying to corruption in international humanitarian law should be considered separately to human rights concerns. And finally, they expressed real significant concerns about resource constraints. So you see that the obstacles, even though the initial inquiry was launched and proposed by the Foreign Minister and there was strong bipartisan support, the challenges sat within the Department of Foreign Affairs and Trade and the Ministry of Foreign Affairs equivalent. So what did the Parliamentary Committee come out and say? Well, thankfully, the Parliamentary Committee, they handed down their report in December 2020, and they put forward a really progressive roadmap for a Magnitsky law in Australia. That included the development of a standalone new Magnitsky law rather than amendment to the existing sanctions framework. While not all the recommendations from civil society were taken up, including, I mentioned the need to include international humanitarian law as a sanctionable activity or violations rather, many of them were, including on issues such as procedural fairness and reporting, which I've discussed. And that's provided a really solid platform for further advocacy. So what are the next steps for a Magnitsky law in Australia? Unfortunately, we're still waiting on the government to issue their response to the parliamentary inquiry report. So we're well over 6 months now. Save the Children, along with many other civil society organisations, has been urging the government to respond, writing letters, speaking about the issue publicly, meeting with government officials, parliamentarians, and using global developments to speak about the necessity. I spent last week in the capital in Canberra speaking about these very issues, speaking to a wide range of stakeholders. Some developments regionally have helped push greater attention on this. Hong Kong organisations held an ad campaign in newspapers. Myanmar diaspora groups have been using the February coup as another push to outline the need for legislative reform. So really the major obstacle, in my view now, is the Department of Foreign Affairs and Trade. My sense is, and I should also note that I'm a former official in the Department of Foreign Affairs and Trade, so I speak with some degree of authority and knowledge from this place, is that their primary concerns are that initially it's bureaucratic inertia. So there's a tendency towards established processes, which often doesn't include sanctions as human rights orientated response. That's a preference more towards soft diplomatic actions. There's also a genuine concern about the resource implications that Magnitsky laws would face and a fear around additional resources that would not be provided. And I've spoken to government officials about this, and that was raised in the inquiry report. And thirdly, there's a hesitancy towards engaging in a more detailed way with civil society and unnecessarily lifting expectations about Australia and what it can do. So In conclusion, despite this sort of degree of pessimism around views from bureaucracy, I do feel quite optimistic about developments given the weight of public support. It's more a matter of when, not if, a Magnitsky bill will be introduced into the Australian Parliament. I'm quite hopeful that we could see something before the next federal election in Australia, which is due by May 2022. It's quite possible we could see something before the end of this year. I think the introduction of a bill in Australia will provide another moment, not just from an Australian perspective, but internationally, to consider how a best possible model can be developed and introduced into law. So looking at where the gaps and issues are in other laws, whether that's the US, UK, Canada, or elsewhere, and see where reforms, especially to engage civil society, increase transparency and ensure greater consistency can be undertaken. Thank you very much for having me. I'll leave it there and looking forward to hearing your questions in the discussion. Thank you.
Thank you very much, Mr. Henderson. Now, if I may invite Professor Akira Igata. He's a visiting professor at Tama University, but most importantly, the leading academic in international and Japan's movement for Magnitsky law. Without further ado, please, Professor Igata.
Thank you, Kihara-Hunt sensei, and also thank you to Doi-san from Human Rights Watch Japan for inviting me again to this timely and important virtual symposium. Hi, everyone. My name is Akira Igata, and I am the visiting professor and also the executive director at the Center for Rulemaking Strategies at Tama University. I'm also the economic security advisor of an international cross-party group of parliamentary members called the Inter-Parliamentary Alliance on China, or IPAC. IPAC now consists of 20 democratic parliaments and over 200 legislative members across these parliaments. I'm glad to see that Honorable Irwin Cotler is joining us today for a comment as well, who is also a Canadian co-chair of IPAC. And in my position as an advisor to IPAC, I have been working closely with the government and the Japanese Diet on the issue of the Magnitsky Act. So first, let me share with you an update on where we stand regarding the debate surrounding the establishment of the Magnitsky Act in Japan since the last virtual conference that University of Tokyo and Human Rights Watch Japan held 3 months ago. Japan currently does not have a sanction law that allows for the government to engage in a Magnitsky-style sanctions through asset freezes or visa restrictions for egregious human rights violations. The only instances where Japan have conducted these types of sanctions in the past have been in conjunction with the United Nations Security Council resolution or joining sanctions conducted by a substantial number of countries. The discussion over potentially passing a Japanese version of the Magnitsky Act has been taking place since last summer at a non-partisan Diet members group called the Japan Parliamentary Alliance on China, or JPAC. As the name suggests, JPAC is a group that's working closely with IPAC, and here, various Diet members have been discussing pros and cons of Japan having a sanctions tool for egregious human rights violations. The main forum of legislative discussion for the Magnitsky Act in Japan had since then moved away from JPAC to a new group with a longer name and without a good acronym called the Non-Partisan Parliamentary Association for Reconsidering Human Rights Diplomacy. Now I know that's a mouthful, but this seemingly cosmetic change was made so that two political parties that had been reluctant to join IPAC for not wanting to be seen as being associated with a group that sounds anti-China can join the discussion, namely Komeito, which is the ruling coalition party with the Liberal Democratic Party, and the Japan Communist Party. As others have already explained, the Magnitsky Act is not an anti-China legislation. It's a sanctions tool that can be used against any individuals or groups around the world. So it was necessary for Japan to create a truly non-partisan legislative group that has all major parties involved in the discussions. This new non-partisan group was successfully established in April with a buy-in from all parties. However, getting here was through a bit of a rocky road. There was a kickoff meeting of this new group among the core members before the official inauguration of the group. But on the very morning of the kickoff meeting, the member from Komeito had to drop out, presumably due to pressure from Komeito's leadership. Now I say presumably here, since the Komeito leadership actually came out during this time publicly opposing the Magnitsky Act for Japan. However, Due to a backlash against this stance from the public, the Komeito members showed up at the very last minute on the day of the inaugural non-partisan group meeting. Once again, presumably because they didn't want to be seen as the only party opposing the initiative to even discuss the issue. And with that, the Non-Partisan Parliamentary Association for Reconsidering Human Rights Diplomacy was established on April 6. This group has expanded in number, and it currently has 83 Diet members with all major parties on board. It has conducted several meetings already by inviting officials from the European External Action Services and the United States Embassy to discuss how these governments are using human rights violation sanctions tool and how they are conducting human rights diplomacy in general. Gen Nakatani from the LDP and Shiori Yamao from Democratic Party for the People are the two co-chairs of IPAC, JPAC, and this new non-partisan group, and they continue to be the leader in pushing this initiative. They have not only led the efforts in the Diet, but also worked with the Japanese media, most notably appearing in a famous Japanese political TV debate program called BS Fuji Prime News, and argued for why Japan needs this sanctions tool, along with two other Chinese academics who argued against it. One personally sad news is that Shiori Yamao has just announced a couple of hours ago that she won't be running for re-election in the upcoming election. The election in October will likely end up with a new roster of Diet members other than her as well. So I think that the institutional strengths of this new non-partisan group will be tested when the election is over. But with the end of the Diet session yesterday and the election looming in the coming months, we would like to see a halt of any developments from the Japanese Diet regarding this Magnitsky Act until later this year. In addition to these cross-party developments, there have been more willingness from individual political parties to begin considering passing some kind of human rights violation sanctions mechanisms as well. For instance, the Liberal Democratic Party has created a project team on human rights diplomacy and came out with a recommendation last month that included the need for Japan to start considering Human Rights Violation Sanctions Act that allows for the government to retain comprehensive diplomatic decision-making. Now, I think there's a mixed message here in that it's quite significant that this provision was written under short-term goals instead of mid to long goals. What's unfortunate is that the recommendation simply states that the LDP needs to, quote, begin consideration of, end quote, establishing a new law, and doesn't specifically state that they need to establish the law per se. We're also seeing similar developments from other opposition parties as well. Both the Constitutional Democratic Party and the Democratic Party for the People seem to have been discussing the issue of the Magnitsky Act in their respective parties' foreign policy and security party committees. And from what I've heard, many of them are for Japan passing a law that will give Japan the option to sanction those that engages in egregious human rights violations. So looking at the future, I see 4 issues that must be resolved. First is addressing whether or not a new legislation is actually really necessary for Japan to engage in the Magnitsky-style sanctions. I've recently heard many arguments that there's actually no need for a new legislation to engage in the Magnitsky-style sanctions and that changing the interpretation of the current Japanese law would be enough. Now, on this point, I personally think that this is a bit of a stretch, given the fact that various ministries are actually on the record stating that current Japanese laws do not allow Japan to engage in Magnitsky-style sanctions during this Diet interpolations during this Diet session. Second is the issue of parliamentary oversight. The current draft version of the Japanese Magnitsky Act has 2 ways of imposing sanctions. One way is for the government to determine human rights violations from occurring and deciding on who to sanction without any Diet inclusion. But there's a second way of doing this, which is for the Japanese Diet to ask the executive branch to conduct research on certain human rights violations and then to report back to the Diet what their findings were and whether or not they intend on engaging in sanctions or not. Now, this is a very strong parliamentary oversight trigger. And there are obviously those who want to have the power to be able to invoke sanctions for human rights violations when the executive branch wants to, but who do not want the legislatures to have the power to request the government to look into potential human rights violations, which will mandate the government to report to the Diet of their results. Now, it is worth noting here, though, that even in the second case, the ultimate final decision on whether or not to sanctions resides with the government. There are also a good number of people from politics, bureaucracy, and the business sector who are afraid of potential retaliations should Japan decide to pass this act and use it to sanction authorities. As such, I think that the executive and the legislature need to come to a compromise on whether or not this parliamentary trigger should remain or not. And if it is to remain, what the threshold is for the Diet to request the government to look into human rights violations. Third is prioritization from the government. In the end, the government and the ruling party must prioritize the issue, or else it will have a hard time passing in the Diet when there are numerous laws that needs to be passed. So whether or not this will happen depends entirely on what happens in the upcoming election, which is currently looking likely to be in October. Which brings us to the fourth and last, perhaps the most important issue, public awareness. The public has been increasingly exposed to the issues surrounding the Magnitsky Act through news articles and TV reports. The recently coordinated Magnitsky sanctions by US, UK, Canada, and EU against human rights violations in Xinjiang was reported widely in Japan. So has the deteriorating situation in Myanmar. However, the Magnitsky Act is still a new concept, so there's still a lot of Japanese people who has never heard of the law or the complicated details behind the debate on Magnitsky Act and Japan's human rights diplomacy in general. If the Japanese public determines that this issue is worth prioritizing, then they will vote accordingly, which will lead to the politicians prioritizing the issue. I am currently rapidly writing a book on this topic in Japanese so that the Japanese public can read about it and learn more about the issues so that they can think about whether or not Japan should have the tool to allow for human rights violation sanctions and more generally, what kind of human rights diplomacy Japan should take. That's for my opening remarks. I'm looking forward to your questions.
Thank you very much, Professor Igata. That is a lot of development and we learn a lot. We now would like to invite Professor Irwin Cotler. He's joining to talk, to give remarks about either about Canada or to reflect on the examples that we are highlighting today. So Professor Cotler, if you can unmute yourself and speak. Thank you.
Thank you for this, and may I begin by commending the University of Tokyo and Human Rights Watch and fellow organizers for organizing this timely and significant seminar, re the global justice movement, because it is more than just, as we've heard from our speakers in terms of adoption of legislation, it's part of a larger movement which engages not only parliamentarians, civil society, and the like, in a movement, as I say, for global justice to help secure justice for the victims and accountability for human rights violators. And I'm delighted that this is being done in comparative perspective and, in fact, deploying comparative metrics for such an effective inquiry. As it happens, this seminar takes place at an important inflection moment with respect to the Magnitsky global justice movement, where we are witnessing, if I can use the term, not only are we experiencing still painfully a COVID-19 pandemic with all the humanitarian suffering, death, and tragedy, but we are witnessing and have been witnessing for some time a global political pandemic characterized by a resurgent global authoritarianism, which is underpinned, as we've heard from our speakers, by cultures of corruption and criminality. We've been witnessing the backsliding of the democracies, assaults on human rights, and political prisoners, if I may say so, as a looking glass into this global political pandemic. The whole, regrettably, underpinned by a culture of impunity. That is why the adoption by the EU of Magnitsky sanctions was such a game changer in that regard. And that is why the adoption prospectively of a Magnitsky sanctions regime by both Australia and Japan, being as they are such important and significant Asian democracies and within the international democracy movement, is crucial for the global justice Magnitsky movement in particular. We're witnessing also, at the same time as this global political pandemic, we've been witnessing what I would call heroic human rights and protest movements from Belarus to Sudan, from Myanmar to Iran, from Venezuela to Saudi Arabia. One of the interesting phenomenon has been the extent to which many of these movements have been led by women, whether we are looking at Saudi Arabia or Iran and the like. But regrettably, this has resulted in dramatic increases in the arrests, in detentions, in imprisonment of these human rights defenders. For example, in Russia, and it has not been that well noted, though we know about the dramatic crackdown related to Alexander Navalny and the like, but there's been in Russia a 10-fold increase in political prisoners in the last 5 years alone. In Belarus, we have seen a massive crackdown on resulting in political prisoners, which included even the downing of an aircraft for the purposes of arresting a political prisoner. In Iran, we have seen a massive repression of the Iranian women's rights movements and groups like the Baha'i or environmentalists and the like. In Saudi Arabia, we have seen a situation where Mohammed bin Salman institutes a reform to give women the right to drive and then imprisons the very women who called for the reform of the right to drive. And then in China, in Xi Jinping's China, and I should use even for the others, Khamenei's Iran and the like, because these are situations where we have to distinguish the people and publics of Iran, for example, from Khamenei's Iran, where the people and publics of Iran are the targets of mass domestic repression. And where in Xi Jinping's China, we are witnessing a multi-pronged assault on the rules-based international order, dramatized by the targeting of what Xi Jinping's leadership have called the 5 poisons, the mass atrocities targeting the Uyghurs, where reports have referred to this as being acts constitutive of genocide. The frontal assault on the rule of law in Hong Kong, threatening not only the democratic movement, the democracy movement, but democracy itself, and arrests as we meet today with regard to journalists in Hong Kong. The continued persecution and prosecution of the Falun Gong, a spiritual meditation group, the repression of the Tibetans, menacing of Taiwanese, and what is not so well known, that Xi Jinping's China arrests more journalists than in any other country in the world. Indeed, one of the more disturbing phenomenon of this global political pandemic and its relationship to our theme today of Magnitsky sanctions has been the increasing arrests, detentions, and imprisonments of journalists. And where, as the high-level panel of legal experts on media freedom, as it's called, where I'm a member from Canada, and its deputy chair, Amal Clooney, in the first of our reports, singled out the fact not only about the increasing assaults on media freedom, on the safety and security of journalists, but the fact that Magnitsky sanctions have rarely been used with respect to securing justice for journalists and holding the human rights violators accountable. So the assault on media freedom, therefore, invites us to engage with regard to the use and application of Magnitsky sanctions, particularly because of the importance of media freedom as a linchpin, not only of freedom of expression, but as a linchpin of democracy as a as a whole. And so I end where I begin, that what we are all engaged in, and I want to commend the speakers for their very important, reflective, and indeed sets of recommendations in this regard. What we are engaged in is, in a word, securing justice for victims of these human rights violations and seeking and securing accountability for the human rights violators. The whole in the pursuit of the common cause with which we are engaged, the pursuit of domestic and international justice. Thank you.
Thank you. Thank you very much, Professor Cotler, and for coming with a very short notice. Now, I would like to invite the questions and answers forum, and I'm handing over to Ms. Mei Kanehara, who will be moderating this. Please, Mei.
Okay, so thank you all so much for your very insightful presentations. We would now like to proceed on to the Q&A component of today's seminar. I will be reading out a few questions that we have received, and we'll be opening the floor up to any answers. It would be greatly appreciated if everyone could keep their answers under 2 minutes due to the time constraints that we have. So the first question is, how much does the law contribute to changing the attitude of the actors and states? And does it improve the situation for vulnerable people? Ms. Portela, would that be a hand raised?
Yes. Okay, so I'm happy to take this question. Actually, this is one of my main concerns, particularly in terms of presenting it to the public. Professor Igata was mentioning the fact that the public is not aware of this sanctions regime. And I feel that in general, if we compare the practice of sanctions imposition in countries that are not located in the Anglo-Saxon world, and the public awareness or the public perception, we clearly have a discrepancy. Most of the public is normally not informed about the purpose of sanctions policy. So it seems to me that in order to make this instrument work, a major effort needs to be dedicated to explain and justify to the public why this instrument is necessary and why it is useful. Because as the member of the public who asked this question has evidenced, there are not that many episodes in which sanctions imposition have brought about a positive development in the country targeted. So this is not to say that sanctions are not useful or that they should not be imposed, because they also perform other functions in international relations. So what I'm saying is not that sanctions are not effective, but there is very little that the sender governments can put on the table in order to persuade the public that they are automatically, by their mere imposition, contributing to rectification of the human rights violations committed or to any improvement in the situation in the countries concerned. Now, I think the key elements that should be highlighted in a public diplomacy effort is, first of all, that they have a deterrent effect. So they might not automatically bring about an improvement in the situation they are protesting about, but at the same time, they are raising the cost of conducting or perpetuating these policies, so that either the government that is affected or the group or individuals who are affected, and also governments or actors in third countries, it becomes clear to them that it is not completely cost-free to perpetrate these human rights violations. And the idea is that giving this message is something that will influence their decisions in future. So we might not face a short-term improvement, but we will hopefully see a positive development over time. And secondly, it is also important to make it clear to the public that the imposition of sanctions for human rights violations are first and foremost about accountability. They are about accountability. They are not first and foremost about bringing about a change in the policies of the targeted actors. So there is already a value in the imposition of sanctions because if we consider that the objective is to promote accountability. So in the absence of such a justification or any explanation that shows to the citizens of the sender countries and beyond what is the purpose of imposing these sanctions, there is a high risk that there will be a misunderstanding and that these sanctions might actually prove unpopular. Because in some cases, we are actually going to witness a backlash. We saw that in China, we saw that with Russia, and we might actually see it also elsewhere, that the target actually reacts negatively. It does not only change behavior, but it actually reacts negatively but by striking back. So, thanks a lot for the question.
Thank you very much, Professor Portela. If there are no further comments regarding this question, Paul, would you like to address the question?
Right. Yeah. Can I make a short comment on that? I thought Professor Portela's kind of explanation of the deterrence effect was quite I guess it kind of summarized like the debate going on with individual targeted sanctions. But I'd also like to kind of point out a unique aspect of the Magnitsky sanction itself and its ability to kind of target perpetrators of corruption. And I guess there's like two ways that a state that I've kind of seen responds to Magnitsky sanctions targeting maybe their state officials or their private citizens. One is clearly like has been kind of portrayed in the media as like the like Russian officials or Chinese kind of officials being very aggressive in their response. And like, for example, Russia, I believe like in 2014 kind of introduced a counter legislation that kind of prohibited the adoption of Russian orphans by American parents. So that's one way where it's a very aggressive response. But I've also seen some sort of like kind of introspection, if you want to say, like where, for example, like after some Mexican officials and their businesses were targeted in 2020, I think Mexico introduced key reforms to their public tender processes. South Africa, I think in 2019, also responded with procurement reforms. So by placing these like private citizens in the Magnitsky sanctions list, it kind of highlights issues within their domestic anti-corruption efforts that actually lead to changes in the financial system. And there's a lot of other examples. For example, I think Serbia also passed anti-corruption law recently in 2020 after I think arms dealers were implicated in the US Global Magnitsky Act. So on the point of deterrence, like it also deters just individual perpetrators, but it also incentivizes states to act on behalf of that.
Thank you very much, Paul. Professor Igata, would you like to add on to this point? Professor, I think you are muted, Professor Igata.
Can you hear me now?
Yes.
Perfect. So just very shortly, having the option to use carrots and sticks, I think, is the basis of engaging in adaptive diplomacy everywhere. But in the case of Japan, we only have carrots and the threat of taking away carrots in terms of human rights violations. And I really think that deciding to have sticks, to have the option to engage in sanctions will likely have a deterring effect. I also think that it's a very strong signaling mechanism in that I think we've all seen so many instances where governments send strongly worded letters and statements and nothing really happening. So having another another option to show that how these governments do not approve of what's going on in their country, it would be a useful endeavor.
Thank you very much, Professor Igata. If there are no further comments regarding this question, I would like to move on to the next. So there are many concerns regarding the sanctions that are applied towards the children of targeted persons under Magnitsky law. Where was this model first derived from, and what are your thoughts about this topic? Perhaps we could have Mr. Henderson address this comment.
Yeah, certainly. Thank you. Happy to address this comment. And in terms of where it originated from, I might defer to the other speakers on that point who have more knowledge about the origins. But in terms of the applicability to children, this issue did come up in the Australian Parliamentary Inquiry. Save the Children did give this a very careful consideration. We had consultation with a wide range of groups. The issue of its application to children, we were particularly concerned about where, especially in cases of corruption, where ill-gotten wealth might be channeled through the sons or daughters of corrupt leaders and practices. And so we do know of military leaders or dictators who might be sending their children to very expensive universities or schools in other countries and doing so through ill-gotten finances. So one part of the process of sanctioning that type of activity is something that we think is a fair and reasonable approach. But again, I think it also comes back to the earlier questions as well, ensuring that there are appropriate due process and procedural fairness considerations that are brought into place so that they're not unnecessarily or applied incorrectly.
Thank you very much, Mr. Henderson. Would anyone else like to comment on this point? Okay, seeing none, I would like to proceed on to the next question. So sanctions usually have extraterritorial effects. How could a wrongful listing for acid freezes be challenged and redressed? And what about the sanction that was implemented by a state in accordance with the UN Security Council resolutions?
Thank you very much for giving me the word. I still haven't figured out how to raise my hand. So in any case, I just wanted to comment briefly on this idea that sanctions often have extraterritorial effects. This is entirely true, but it only applies to the sanctions imposed by the United States. It does not apply to sanctions imposed by the European Union or other actors. Actually, the European Union has been contesting the legality of imposing sanctions with extraterritorial effects. So this is basically a legal controversy, but I mean, it might actually interfere with the common efforts. The common efforts to impose sanctions by let's say the allies of the United States or the like-minded countries, as I have called them before. So for the time being, there is still a dispute between the European Union and the United States about the legality or the permissibility of imposing sanctions with extraterritorial effects. So it doesn't seem to me that this is something that can be generalized. On the contrary, it is a source of friction between partners on both sides of the Atlantic. And perhaps the other speakers can also comment on how their own countries position themselves in this dispute. Thank you.
Thank you very much, Professor Portela. Mr. Henderson, would you like to add on to this point?
Yes, so in terms of how a wrongful listing or freezing could be challenged, I think there's a few processes that you would need. Firstly, you need a process that sets out the procedural fairness guarantees, so includes a statement of reasons and then an opportunity to make a submission before final sanctions are applied. Secondly, you would need access to an independent merits review and or a statutory judicial review process. Thirdly, and this is really important, you need a regular review by the minister and an automatic review when new evidence arises. So that's especially important. And then you would need to provide individuals with the right to request revocation and a process for that. As to the question about the sanction and whether that was implemented in accordance with the UNSC resolutions. There are provisions, for example, in the United Nations Charter Act, Section 16 for Australia, the minister can revoke a listing if they're satisfied it's no longer necessary to give effect to a particular resolution that the Security Council has given. Australia's no longer required to carry that out and or no longer relates to terrorism or dealing with assets that are related. So ensuring that those provisions are in the legislation to begin with is really important, but we do have models in some legislative pieces already.
Thank you very much, Mr. Henderson. If there are no further comments regarding this question, I would like to proceed on to the next. So this question can perhaps be answered by Professor Igata. When do you think Japan will introduce the law and will actually start using it?
Thanks for the question. So as I talked about in my presentation, I think we have to wait to see what happens in the election in October. But I do want to note that passing the law and using the law is actually two very different things. First of all, once again, having the option to use carrots and sticks is the basis of engaging in adept diplomacy. But Japan doesn't currently even have the option to engage in sanctions because we don't have the tools. So I think it's easier to argue that first, let's have both carrots and sticks so that we always have the option of using them. So I think there's a stronger case to be made for Japan to pass the law. Now, once we have the law, when do we use it? Now, that's a real question here. I think that depending on who you talk to, there is a bigger gap in terms of who they should sanction. And especially with regards to country where Japan currently has a high geopolitical tension, there's actually a real debate going on as to whether or not, even if we pass the law, we may not be able to sanction certain countries because of fears of retaliation. But I mean, I think that the first thing we need to do is really, come up with consensus on whether or not to have this kind of law in the first place. And I think for that, the question is easier to answer. And that is, yes, we do need a law.
Thank you very much, Professor Igata. Would anyone else like to add on to this point? Okay, seeing none, I won't be proceeding on to the next question. So what is the benefit of having human rights violations and corruptions considered separately, if any? Perhaps Mr. Henderson or Mr. Cotler can address this question.
I'm happy to provide some brief comments. I think my view is certainly that they should be considered under the same piece of legislation to ensure that there is greater consistency between the models that are being applied in different jurisdictions. And that also ensures that all the other processes that sit underneath that act, so whether that's due process requirements, whether that's reporting requirements, whether that's parliamentary oversight mechanisms, would be included, whether a sanction is applied on the basis of a matter of corruption, human rights violations, or, as I've also talked about, international humanitarian law violations.
Thank you very much. Mr. Cotler, I think your mic is muted.
Yeah, right.
You.
No, I concur with Simon. I think they need to be integrated into the same piece of legislation for the reasons that he mentioned, whether it be the due process considerations, the oversight considerations, and also to have an integrated approach with respect to both justice for victims and, as I said, accountability for the violators. So it also will help to make the point that we are not targeting countries or governments, we're targeting individuals. And by putting those two together, I think we make that point more compelling.
Thank you very much, Mr. Cotler. And for the last question of the day, I would like to ask, what is going to happen to the frozen assets? Could they be eventually returned to the state? Could they be distributed to the victims as reparation? And are there any discussions concerning this matter?
Well, I'll jump in just for a moment because together with Brandon Silver, our director of the Magnitsky Justice Regime at our Raoul Wallenberg Center for Human Rights, we wrote an article about the importance of repurposing the assets and seeing that they can be returned by way of reparations and restorative justice to the victims themselves.
Thank you very much, Mr. Cotler. Mr. Henderson?
Yes, thank you. And this issue didn't come up in substantive detail in terms of the Australian Parliamentary Inquiry, but I think there's certainly some good examples that can be taken from victims of crime legislation, which already operates in many domestic jurisdictions that enable seized assets to be redistributed back to measures such as restorative justice mechanisms. So I would agree with Professor Cotler that there are certainly examples elsewhere of where that could be done, and that would be consistent with restorative justice principles.
Thank you very much, Mr. Henderson. Professor Igata?
Very briefly, I just wanted to share that there are no discussions going on regarding the repurposing of frozen asset at the moment here.
Okay, thank you everyone for your incredibly insightful discussions and input. This concludes the Q&A component of today's seminar. And next we would like to move on to any last commentaries.
Thank you very much, everybody. My name is Kanae Doi, Japan Director of Human Rights Watch. First of all, thank you very much for the University of Tokyo, the team headed by Professor Kihara-Hunt. Your really strong team has really helped to mobilize the audience to listen to this very important seminar. So once again, thank you so much. In order to make Japan to introduce a type of Magnitsky law, we really, this seminar showed how important it is for the civil society to re-engage and then double our efforts within the Diet, as well as to inform the public about the need of this law. Particularly, I was struck by the news that the MP Shiori Yamao, who has really led the efforts within the Diet, is not going to run for the next general election, which is a huge loss for us, for the law to be introduced in Japan. So we really need to redouble our efforts. But again, I would like to thank the University of Tokyo, and then we know that we are preparing the third seminar on 8th July, Thursday, from noon JST. University of Tokyo is really essentially the one, I would say only one, perhaps the main, but the only one educational institution who has really led their discussions about the Magnitsky law in Japan. So I'm really thankful for you. And then I hope that we would see you once again at this third seminar on Magnitsky law in Japan.
Thank you very much, Kanae-san. I'm sorry, I wasn't sure if I was to give you an introduction to get you to speak. So yeah, she was our main and the only, again, counterpart on this. So great, thank you very much. And I just want to close this seminar by thanking everybody. Thank you very much for the co-organizer Human Rights Watch for taking our, we have a lot of enthusiasm, but we need a partner and vehicle to have a network, and the Human Rights Watch has been a great partner for this effort. So thank you very much. Kanae-san and Human Rights Watch. And thank you very much for speakers, Professor Clara Portela, for accepting invitation from out of nowhere, and Mr. Simon Henderson for continuously supporting our seminar and appearing on the seminar. Professor Akira Igata, who's been the leading figure for Japan, and we have always wanted to invite you, but your response was within a second. So we really thank you for participation. And Professor Irwin Cotler for reappearing and agreeing to speak with a one-day notice. Thank you so much. And I also want to thank simultaneous translators, Yuko-san and Daniel-san, who've been providing this simultaneous translation, which is basically impossible with all this enthusiasm and very fast speakers. I'm sure we gave you a lot of problems, but thank you so much. We are very happy to approach the Japanese crowd, and enable the world to approach Japanese crowd. And lastly, but not least, thank you very much for the hub team. Paul, Satoko, Mei, and Chihiro, and Raymond, who was also in this team of Magnitsky research. So thank you very much. And as Kanae-san said, we will announce to those people who have said, yes, we want the news for Magnitsky Law about the details of a next seminar, which is just confirmed on 8th of July, which will be focusing a lot on freedom of expression and safety of journalists. So thank you very much. And we would like to close here. Thank you.